Good morning to those of you on the West Coast and good afternoon to those of you on the East Coast. My name is Felix Shipkevich and I have the pleasure to be joined today by my partner and colleague, Christina and Endara. And today we'll present a webinar which is being recorded and will be available on our firm's website, which I'll provide more information a little bit later. In case you want to go back to any of the slides. Today we'll discuss the debt relief industry enforcement update and trends for 2021. For those of you who are our webinar's loyal listeners, welcome back. It's been a while. The last webinar that we did was in December 2020, and as you can imagine, 2021 has been busy year for many of us, particularly in the legal field, and we're delighted to come back to our webinar series, and we'll be doing around different types of webinars over the course of the next few months, leading up to our law firm's regulatory workshop, which I will mention very briefly. For those of you who are joining us for the first time, we hope that you will become loyal listeners, and please feel free to follow our website and information about the debt relief industry on our firm's website, debtreliefwatch.com. Okay. All right. A little about me. I'll keep it very brief and short. I'm a New York City-based attorney. I run a boutique firm with 2 additional offices. One we recently opened in Miami, Florida, which is spearheaded by Christina, and she'll discuss that really shortly. And we have a small office in London. I do a lot of work for close to 2 decades in the regulatory M&A and fintech space, primarily representing banks, broker-dealers, technology companies, debt relief companies, credit counseling, and many other small to large entities in assisting them to navigate complex regulatory issues and essentially help them grow our business. In addition to practicing law, I do what I enjoy the most in my career, which is teach law, and I teach that at Hofstra Law School. I've been teaching now, this is my 5th year. I've taught a number of courses, including corporate finance, and my favorite course, which is called The Policy and Business of Cryptocurrencies. Of course, nothing to do with this subject matter, but I have enjoyed teaching that for a number of years. And finally, I'm a member. I sit on the board and the secretary of Consumer Debt Relief Initiative, which is a trade industry association in the debt relief space, and I'm very proud to be part of it. I think we're doing a lot of fantastic things. Now I'll turn it over to Christina to introduce herself.
Thank you for the introduction, Felix. And again, thank you everyone for being here. We really appreciate everyone taking the time out of their busy schedules to log on. As Felix mentioned, my name is Krystina Endara, and I'm a partner of the firm, and I lead the firm's Florida office. Just by way of background, I graduated from the University of Miami School of Law in 2017. I have practiced commercial and complex commercial litigation for about 4 years, until recently, where I shifted my practice to the fintech, debt relief space, and emerging digital currency sectors. Having a background in financial sales in the debt relief space, and having also worked a lot with investment vehicles in law school and even interned with the SEC, I always knew that I had a keen interest in this type of work. So I'm really, really excited to finally be dedicating myself to it. And I'm really happy to be hosting this enforcement update for you guys. We hope that you enjoy it and that you find it to be informative. So without further ado, I will let Felix take it away.
Thanks, Christina. And before we proceed with the enforcement update, let me make a quick pitch to our regulatory workshop that I just mentioned. It is going to be an in-person workshop on September 7th and 8th. It's going to start in the late afternoon on the 7th and go through the remainder of the day in the 8th. We have a fantastic agenda listed on our website. We plan to have a regulatory panel and have invited regulators to speak. And ultimately, our attorneys, myself, Christina, Yvonne, and our staff will be there. You'll get a chance to meet us. It is reasonably priced. It does include a breakfast, lunch, and an evening event, which is sponsored by Veritas Legal Plan. We have lunch that will be sponsored by Reliant. And we have Lending USA and also Finxera that's has expressed interest and will be now sending an announcement. Many different vendors in the space. And for those of you who attended our workshop, our first workshop in 2019, I think we're fairly happy. We got great feedback. We had over 40 companies attend the event. So if you reside in Southern California, we hope to see you there. If you don't, please visit. We actually have great hotel rooms with Westin, and we'll send out a separate email. So anyway, without further ado, let's talk about the 800-pound gorilla, or gorillas, right? The CFPB and the FTC, and talk about what lays ahead and how do we tackle it, right? For those of you, again, who have previously listened to my webcast and my webinars, I try not to necessarily read off the slides. This is available for information purposes, and you can go back, it's recorded, and read through them. But look, we have a new administration. We have a lot of major changes in Washington, both on the CFPB and the FTC level. We have an imminent arrival, very likely for Rohit Chopra to be sworn as director of the CFPB. He's a commissioner at the FTC. And the overall enforcement effort on the CFPB side is going to be quite aggressive. You probably read it from our Debt Relief Watch newsletters, announcements. You read it in major publications like Wall Street Journal, The Times, and Reuters. It is going to be a bumpy few years. And don't look at it. We're not here to scare you like most lawyers. Oh, let's spook everybody that it's going to be bumpy and we should all hide or, be too scared. The reality is we're living through a global pandemic. Many consumers have been struggling and, going to, be in significant debt, particularly once the moratorium on evictions will be lifted. I know that there was an emergency limited moratorium extended quite recently, but at some point the moratorium on evictions and the government payments will subside or stop at some point. Hopefully we're not going to be in this global pandemic for the rest of our lives, right? I mean, that would be quite terrible. So, and many people will be in distress. And so the CFPB has the powers and the right to protect consumers. And primarily and substantially, they've been focusing, at least in the past year, on two sectors. The one is really the mortgage sector, right? They've been looking at to make sure that consumers are not being misled by the mortgage industry. And also, when I say that, I want to be careful to also include in there by landlords. They're now the CFPB, in my opinion, for the first time, is looking to protect consumers on the real estate side, if we could sort of look at that. On the other side, they're looking at predatory lending practices, and they have taken enforcement actions against lenders. So that's their focus. As we'll discuss further, there will be focusing on the debt settlement industry. We've had discussions, I've had discussions with the CFPB. I've also had discussions with various AG offices and regulators in the past year, and they're looking at certain products and services, and particularly those that violate the TSR. As we broke to some of our clients the news of about 6 months ago, they're looking at potentially at the upfront fees charged by debt settlement companies for the ancillary products. There have been no enforcement actions, but it is something that they're looking at very thoroughly. Look, I think that's kind of the forecast ahead. It's going to be a bumpy few years, and not to create any paranoia or scare, but you need to be prepared, and you need to obviously make sure that you're not looking at 21, 22, and 23 as 18, 19, 20, even though technically those years have had their own level of volatility. Anyway, Let's talk about 2020, right? So we haven't had a webinar on this. We haven't had a regulatory update for a year, so we have to round out the 2020. And on the CFPB side, there was really just one case that was filed. And the allegations made by the CFPB are violations of UDAP, TSR, and CFPB violations. And as you could see on the screen, there are specifically 4 bullet points, right? The first one is they had issues with scripts and phone calls with these potential clients. So yes, they do care what you say to your prospective clients, and if there's obviously anything misleading or incorrect or lies, you should definitely go back to it. You know, if you're on the compliance side, I certainly recommend for you to go back after this webinar and to pull your scripts, pull phone calls. I hope you're regularly doing it with your sales staff. The second was not fully disclosing repercussions for not making direct payments to creditors. You know, they felt, the regulators, when I say they, the regulators felt, particularly here, this was the CFPB felt that customers should have been properly disclosed what happens if they stop making payment to creditors. You know, merely being involved, enrolling into a debt settlement program doesn't mean that you're legally protected, right? You are hiring a service for someone to negotiate that on your behalf, but it doesn't mean that, you know, if you stop making those payments, that just will magically disappear. So basically, it's pretty common sense. I don't think there's really anything else to discuss on the second point. Deceptive and lawful upfront fees. Upfront fees is the #1 priority for the CFPB right now. It's a problem, right? The last amendment, particularly including the debt relief, debt settlement companies, was 2010. We're 11 years into it. There's still companies that charge upfront fees, and the CFPB is not happy, and they're looking at it. So the forecast until our next webinar on the subject matter is that there will be more violations of TSR. And Christina will talk about it specifically on the student loan side. But yes, upfront fees are still a big problem, and the CFPB is looking into it. And finally, lack of clear and concise disclosures of the process and time it would take to pay off debt. That's pretty clear. It's also part of TSR. It's one of the elements of TSR. If you're not, if you're not familiar with one of the several prongs of disclosure to consumers prior to enrolling debt settlement programs, this is one of those. So it is also pretty self-explanatory. Now, we're 8 months into 2021, and considering summers may typically be slow, we already have 2 enforcement actions from the CFPB against that settlement companies. 2, right? So 1 in 2020, 2 in the first 8 months, right? And you're probably saying to yourself, well, 1 or 2, what's the difference? It's not so big. But we'll discuss in a few minutes how it's not necessarily being done by the CFPB or the FTC, but in fact, there's a tremendous rise of enforcement actions by state regulators, right? So the state regulators are going after debt settlement companies, student relief companies, credit repair companies, and they're quite aggressive. And I have to tell you today, since Christina and I on the front lines, the state regulators have become more aggressive than ever before. In fact, I would make the following argument that they're more aggressive than the CFPB and the FTC, and that's probably why you only see 2 enforcement actions in 2021 so far from the CFPB. And if you look at the elements, right, they're pretty much mirroring what you had in 2020, 2021 really mirror more or less, and it's also alleging violations of UDAP, TSR, and the CFPA. So we already discussed that. So let's move over to the FTC, right? In 2020 and 21, there's really only one enforcement action by the FTC, right? And if you're cheering and saying, oh, well, we don't really care for the FTC, wait a second, hold your horses. Rohit Chopra is coming over from the FTC to the CFPB, and I can assure you that with his imminent arrival, we're going to have a rise of, we might see a rise both on the CFPB and the FTC side keeping in mind that the states have become quite aggressive. Nevertheless, the allegations, once again, both agencies have the same statutory right to enforce UDEP, TSR, and CFPA. And if you look at these 4 bullet points, they pretty much mirror the 2020-21 allegations made by the enforcement actions of the CFPB. Now, I'm going to turn it over to Christina, and she'll talk about the student loan company enforcement update.
Thank you, Felix, for turning it back over. As Felix mentioned, in this section of the webinar, we're going to be talking about recent trends in enforcement actions against specifically student loan debt relief companies. So Felix touched on this already, but a key takeaway here is that we're seeing a huge rise in state regulatory actions. So what that means is you can have quite possibly a scenario where you have actions by every state where you are servicing consumers, and also the FTC and other federal regulators like the CFPB. I want to start with CFPB regulatory actions and then move on to the FTC actions. Let's talk about 2020 to begin with. So as it relates to the CFPB, what we are seeing as of 2020 is definitely a palpable increase in the enforcement actions against these types of companies. So in 2020, there were 5 enforcement actions brought against student debt relief companies, some in conjunction with state attorney general's offices and some not. Even companies that were shut down prior to any action taken on behalf of the CFPB were named in recent complaints as well. So I want to stop here and talk about this point for a minute. It's not uncommon that we get a call from a client saying, hey, we got a subpoena from a regulatory agency, but the company is shut down, so we don't need to respond, right? Wrong. We have to be mindful that there are statute of limitations on these types of cases. They're normally 3 to 6 years, but of course it depends on the situation. So being shut down does not necessarily mean that you're absolved from responding to something like this. If you receive a request or a phone call, I can tell you that the best practice always is to speak to an attorney. If you think you're going to ignore them, there's always the potential that they can go after you personally. So I definitely do not recommend ignoring them, even if the company has been shut down. Again, we're seeing actions where the CFPB is continuing to go after and name these entities even after they have completely ceased operations, and even year or 2 after they've ceased operations. Felix, do you mind jumping to the next slide for me? So what do the allegations look like in these enforcement actions? They vary, of course, on a case-by-case basis, but the majority of these cases, if not all these cases, include violations of the TSR by charging upfront fees for services. I think Felix touched on this already, but that's definitely the big one. In other words, charging fees before services have been rendered. We also saw allegations that companies were enrolling clients in these programs, but not actually delivering on these services as promised. Allegations of failing to provide sufficient disclosures and embellishing how successful the programs were, or also how successful the companies have been in negotiating any sort of debt relief services. Also, something to be mindful of here is that the CFPB will pursue front-end companies for supporting a back-end company for their own respective violations of the TSR. So just being involved in within a company that is violating the TSR might actually get you into trouble as well. So we're seeing marketing companies who referred consumers to companies who performed the actual debt relief services be named in some of these actions for providing substantial support to the back-end company. And there's a specific section of the TSR that speaks to this. So if you guys want to read more about this, there's a specific section in the TSR that speaks to providing substantial support, and that is actionable. So definitely to be mindful of. Felix, sorry to keep bugging you. The next slide, please. Okay, so what we're seeing in 2021, let's move on from 2020 and go into 2021. This is just a continuance of the trend that we're seeing in 2020. So far in 2021, there has been 1 enforcement action brought against a student loan debt relief company who, again, had not been operational since 2019. So you're seeing a 2021 action for a company that had not been operational until 2 years before that approximately. So the allegations in this case were specifically for violations of the TCPA, TSR, and CFPA. Now, I want to take a moment to talk about another myth or misconception that we see a lot. We get calls where the first thing the client says is, I'm just a dog prep company. I'm not providing student loan debt relief services. Therefore, none of this should really apply to me. While I can certainly appreciate the fact that you are just preparing documents for a consumer, we always say substance over form. So the form is that you're giving it a different label, right? You're calling it document preparation. And so it's different than calling it student debt relief services. However, what is the substance is what we always tell our clients. The substance is that you are still trying to help these clients reduce their student loans or effectuate a change in their repayment. Then in fact, you can be construed as providing student loan debt relief services. And in fact, we have some clients who've come back to us after we've told them this precise thing and they've ignored us, who've come back to us with a bigger problem or with regulatory action on their hands. So again, something to be really mindful of here. Felix, do you mind switching the slide for me? Thank you. The FTC has also finalized 3 enforcement actions against student loan debt relief companies in 2020 with similar allegations. I mean, normally these cases look very similar to the CFPB cases. So the complaints in these cases alleged violations of the TSR and the FTC Act for deceptive marketing issues. They also involved allegations of providing clients with inaccurate assistance in the student loan process, charging upfront fees. As always, it's always a big one. And of course, even companies paying for good reviews, which was also interesting to see. Next slide, please. Thank you. In 2021, the FTC has continued to target student loan debt relief companies and has even brought actions against payment processors who assisted in these violations. So again, we're seeing other companies who weren't directly doing, committing any violations, but who were effectively assisting in violations, processing advance fees, also getting in trouble here and into hot water. Complaints here involved violations of the TSR, TCPA, FTC Act, and similar allegations, of course, as usual, upfront fees and providing assistance to these companies. So I want to just wrap this up by saying that the takeaway here is that there's not so much a rise in CFPB and FTC regulatory actions, though we are seeing that. But like Felix said, it's really just a huge rise in state regulatory actions. So you need to be mindful that states have the ability to prosecute cases in addition to federal regulators, and even have the ability to use federal law against you. So you can have, definitely quite conceivably, a state go after you for violation of the TSR, even though that's federal law, they can still use that against you. And so, you can have a situation where you had the CFPB and the FTC going after you, but then on top of it, you also have the states in each state that you service to consumer as well, like we talked about in the beginning of this. So all stuff to be mindful of, and that actually concludes this section of the webinar. So with that, I will turn it back over to Felix to discuss credit repair companies with you guys.
Thanks, Christina. We included just a brief discussion about credit repair companies. I always view that when you discuss the debt relief industry, you have to also think about the credit counseling and the credit repair companies. I just think that inadvertently somehow the debt relief industry is viewed by just debt settlement companies, and I don't think that's correct, right? In fact, I could make the following statement: bankruptcy attorneys offer debt relief services. In fact, the bankruptcy law, bankruptcy lawyers are required to provide disclosure that they provide debt relief services. So therefore, I thought it would be important to include just a really brief discussion. And look, the bottom line is we've seen actions filed last year against credit repair companies by the CFPB. In 2021, we already have one enforcement action. And if you specifically focus on the complaint focuses on really the same identical type of allegations, violation of telemarketing sales rules, CFPA and UDAP, right? Same exact statutes. It's almost like it should be ingrained in your brain. TSR, CFPA, and UDAP are really what they're focusing. So in the credit repair complaint, the CFPB alleges, and I just want to be very careful to say that these are allegations. So this was also brought. I should also make reference that in conjunction with Georgia's AG's office. That the credit repair company, in this case, allegedly used telemarketing to solicit customers with false promises that the company's services would eliminate credit card debts to improve their credit scores, right? The second is they advertise to potential customers through direct mail list or party lead generation, so-called debt validation program. We'll actually have a webinar coming up, and we'll announce it just specifically for debt validation, regulatory and legal issues. I think that you should definitely pay attention to that. So debt validation is beginning to be on the radar of both federal and state regulators. And the allegation in this complaint also that this company made substantiated and false claims in violation of TSR and CFPA by telling customers that they could restore their credit services and they had a credit restoration team. Anyway, that case is still outstanding. It's just allegations, but obviously we see that the CFPB is looking at credit repair. Similarly, we have one case filed by the Federal Trade Commission. This was a 2020 action, and they're also alleging FCRA and UDEP violations. I think there's really nothing more to say other than that. Just there's a lot of crossover in between debt settlement, credit repair, debt val, credit counseling, and bankruptcy. When I say crossover, if I drew it on the board, if I drew like 5 big circles, a little portion of them would somehow overlap with one of the following services. They don't have to overlap, but they often do, and particularly for those who are on the front end, the marketing side, or if you're working for a debt settlement company that does its own lead generation, you have to be mindful, how you pitch these services. And a very good example, common example is, the question that's asked by sales team is, well, can we say that credit, by enrolling into debt settlement program, you can improve your credit score? And the short answer is, it is technically a credit repair service that you're selling, and you have to be mindful. I mean, there's ways to discuss that, right? There's ways to discuss that. If you make, we're not a credit repair company, but if you obviously make your payments and you pay off your debt, then there's no reason to believe that the credit score may not be improved. But if you promise them, right, that's very different than if you promise them the ability to improve their credit scores, then that becomes the selling of a credit repair service, and you have to be careful with that, and definitely need to go back and read your scripts. Now, we're towards the end of the presentation, but I want you to pay very, very close attention. I mean, we keep harping on the same subject, and if there's one difference from the 2021 versus the 2020 enforcement update, is the fact that the states have been more active than ever before. Extremely active, right? Let's talk about California. So California, many of you who are on this webinar are on the West Coast. I just see it by the names of the participants here. And the CADFPI, which is called the mini CFPB, is trying to flex its muscles, right? It's trying to be the premier leading agency focusing on protecting California consumers. And we've been involved in a couple of matters involving CADFPI, and I could tell you it is quite a different agency today than it was a year to 2 years ago. There's, Manny Alvarez, who was the commissioner, recently left to work, actually, interestingly enough, for one of the leading crypto companies. So we're going to have a new head of the CADFPI, and I imagine that agency will continue to go after certain participants in the debt relief space. When I say debt relief space, again, I don't talk about debt settlement companies, credit repair, student loan, debt val, and so on. We've been involved with a very, very aggressive enforcement action by Pennsylvania AG's office. PA is a very aggressive state, and I can tell you that they sharpen their teeth and they don't joke around. And you know, if you're doing business in the state of Pennsylvania without a license or you're taking upfront fees, I could assure you from experience, mind you, that I was actually for years licensed in Pennsylvania as a lawyer till I retired my license. But regardless of that, I could tell you dealing with Harrisburg is no picnic. Okay, it's almost this you're going to civil war at Gettysburg. You know, it's like a Gettysburg battle in Pennsylvania. Minnesota has been very aggressive, and Wisconsin. These two Midwestern states have been very, very aggressive. Oregon, interestingly enough, has been aggressive as well. Though Oregon has been quite reasonable to deal with, and I commend their enforcement staff for being very reasonable in the enforcement efforts. Unlike, for instance, what I felt was a little too on the aggressive side on the state in the state of the Commonwealth of Pennsylvania. So please pay close attention to state regulators. And as you can see in the final bullet point, just this year alone, just in the first 8 months, we're not even done with the 8th month, but there have been 5 enforcement actions in the state of California. So certainly do not ignore. I mean, this is, you know, if you go back to 2020, you know, my former colleague Bianca Petku, who we missed dearly, she was, you know, we focused on the CFPB and the FTC. Now we're focusing a lot on the states who are enforcing federal law. So key takeaways so far, obviously big administration changes in Washington, both at the CFPB and the FTC level. We are going to see, we expect to see an influx of customer complaints and therefore more investigative and powers by federal regulators, and same for state regulators. Christina, anything else you want to add for the key takeaways from your side?
No, that's everything.
Okay, excellent. And that's it. For those of you who know us, who don't, this is a list of our services we provide in the debt relief space. We do a lot of regulatory litigation investigation work, and please feel free to reach out to us if you have any questions about this webinar or any of the questions that arise. And of course, I make a pitch and every one of these. Please subscribe to the Debt Relief Watch to get our latest alerts. Here's our contact information. I'll leave it up for another 10 seconds. Thank you. We are very grateful that you joined us, and we hope to see you at our future webinars. Thank you, Christina.
Thank you, everyone. Thank you, Felix.